The High Court has lifted the conservatory orders issued by a Kerugoya Law Court, settling in the stage for swearing in of a new Deputy President, designate Kithure Kindiki. In its ruling, the Justice Eric Ogola-led bench ruled that in the spirit of constitutionalism, the office of the Deputy President cannot stay vacant. And as Ruth Wamboi reports, ousted former Deputy President Rigathi Gachagua has suffered a double sword at the courts Thursday, starting from the Court of Appeal in the morning to the High Court in the afternoon.
From the Court of Appeal sitting in the Supreme Court mid-morning Thursday, Gachagua's day looked bleak. The trio bench at the appellate court declined to stop the High Court's bench from issuing a ruling on an application to lift orders that had been scheduled to start at 2:30 p.m. Justices Patrick Kiage, Jojo Dunga and Agri Muchelule directed Gachagua's lawyers to serve the amended application to all parties before midday Friday, giving them a hearing date for 6th November. At Milimani's Law Court, the bench comprising Justices Eric Ogola, Anthony Murima and Lady Justice Freda Mugambe walked in at exactly 2:37 p.m., ready to deliver the much-awaited baby. The court appealed that Gachagua's petitions raise constitutional issues that require further judicial interventions.
Allowing these orders to stand will leave the office of the Deputy President vacant. The problem, however, is that no other person is authorized to carry out the constitutional functions specifically assigned to the Deputy President under Article 147, Sub-Article 2, once those assigned by the President revert to the President in the absence of an office holder. The result would be a de facto suspension of Article 147(2) of the Constitution.
In acknowledging the pre-2010 constitutional differences with the 2010 Constitution, the court ruled that the office of the Deputy President has been redefined and cannot stay vacant.
It is undisputed that the impeachment of the Deputy President is a constitutional process outlined in Article 145 of the Constitution. The authority to determine whether the merits and procedures of such an impeachment process align with constitutional requirements therefore falls squarely within the jurisdiction of the High Court as provided for under Article 165(3)(2).
In casting out doubts from Gachagua's lawyers that the regime will not respect court orders, in the instant Gachagua wins the case, Justice Murima ruled that the court will craft effective remedies.
The Conservatory orders issued on 18th of October 2024 in Kerugoya High Court E015/2024 are hereby discharged and or set aside. Costs of these applications shall be incurred. We grant leave for appeal.
Gachagua's counsel said on Tuesday, led by Senior Counsel Paul Muite and Elisha Ngoya, urged the juries to take judicial notice of the serious violations of the Constitution, the flawed process, among other issues, in the unprecedented rush to oust Rigathi Gachagua.
In my own humble view, it is unfortunate that the court should have taken that kind of stand. They should have allowed the conservative orders to continue to be enforced until we dispose of the whole case.
The respondents on their part, led by Professor Githu Muige and Professor Tom Mojenda, told the bench that a sustained conservatory order would trigger a constitutional crisis in the country.
A position to be held in abeyance because of the role set out under Article 131 and 132 of the Constitution. And so the court is right in discharging these orders. I think what we want to see is this country functioning within the confines of the rule of law.
Parliament or the National Assembly to approve the nominee of the president ought to be done within 60 days. It can be done on the first day, on the 30th day, or on the 60th day. So in terms of timelines, there is nowhere the Constitution talks about 74. It's a fallacy and pure misrepresentation, and the court has seen through that mischief.
With Justice Richard Mongo's orders now vacated, Professor Kithure Kindiki will be sworn in as the new DP tomorrow, 1st November 2024 at the KICC. With the bench, the de facto suspension of some parts of the Constitution is a gross violation of the rule of law, the court has added the last nail to the coffin by citing that the petitioner can only get a remedy at the Court of Appeal in this application. Ruth Wamboi reporting from Milimani's High Court.